What I'm here to talk about today, specifically within the civil side of the equation, is a civil lawsuit. So this is one person has filed a lawsuit against another person, and I'm going to walk you through the process from beginning to end. So most civil actions, this type of civil lawsuit we're talking about, are started by the filing of what's called a complaint. The complaint is filed by the plaintiff in the case. The plaintiff is the person prosecuting or bringing the civil action. Anybody named in the complaint from whom the plaintiff is seeking relief is called a defendant. Again, on the criminal side, we have a criminal defendant. That's different from a civil defendant. On the criminal side, we have the state or the federal government versus somebody. Here, it's an individual plaintiff versus a individual defendant. So what's very important to understand is if you are, unfortunately, in most cases, handed a complaint along with another document called a summons, you have been served as a defendant in a lawsuit. And the moment you are served, a clock starts running, and the clock is generally 20 days long. And you have 20 days to take action to defend the lawsuit, that being filing a defense in the case, and sending your defense papers to the other side. Generally, the response to a complaint is an answer. After the complaint has been filed and the answer has been filed, we move into a phase in the civil arena called discovery. The idea on the civil side is that both parties get what's called full and open discovery, where we do things like take depositions, do document request. Each party does a request to the other side, and we can serve written questions called interrogatories. There's various means of doing what's called discovery, and the idea is both sides get to learn every aspect of the other side's case. So ultimately, if and when we go to trial, there are supposed to be no surprises. Everybody has learned about the other side's case and the facts of the case through discovery, and so we go to trial without surprise. That's the way it's supposed to work. As you move towards the end of the discovery phase, generally you will be required to go to what's called a mediation. A mediation is a process where you sit down in a room, or in these days with COVID, virtually, with an independent person called a mediator who has no authority to decide the case, to make any rulings, to make any decisions. His or her sole role is to assist the party in negotiations to try and settle the case, come to an agreed upon resolution without having to go all the way to trial. And the idea is after the parties have engaged in discovery and learned more about each other's positions, the case is more likely to settle because everybody understands where the other side is coming from, and a better understanding of the other's position usually leads to a better chance, opportunity, and likelihood of a settlement. If the case doesn't settle, generally the next step is to go to trial, and this is again what we see on TV, usually in the criminal context, but not always. There was LA Law, I think Boston Legal had some civil action, but they're far different than what you see on TV. But the general concept is the same. We go there, we have opening statements, we have witnesses, and then we have closing statements to a jury, and then the jury renders a decision. If you are unfortunate enough to come out on the wrong end of a jury trial, such as that, you will, in most cases, have what's called a judgment entered against you. A judgment is just a piece of paper saying, in a monetary dispute, that you owe a certain amount of money, and that piece of paper allows the plaintiff who brought the lawsuit against you and got the judgment to start trying to take your assets to satisfy the judgment, to satisfy the amount owed as set forth in the judgment. Prior to entry of the judgment, generally speaking, the plaintiff has no ability to take your assets. It's the judgment that allows the plaintiff to do that. So it's a very important document, and it's important for this reason as well. The last step of a civil lawsuit, generally speaking, would be an appeal. In most cases here in Florida, you have 30 days from the day that a final judgment is filed in the court file to seek an appeal of that judgment if, again, you were on the losing end at the trial, unfortunately. If you miss that 30-day deadline, it cannot be cured. You have forever lost your right to ever appeal that judgment. It is one of the strictest deadlines in all of the law. At that point, we are pretty much through the various general steps that you have in a lawsuit. All along the way, including when you are initially served with the complaint, if you are sued, and all the way through, as I said, when the judgment is entered against you, there are deadlines that must be complied with throughout the entire process. So it's very important, if at all possible, to have a competent, well-trained attorney assisting you throughout the entire process to ensure that all deadlines are complied with to the best of their ability, and to provide the best opportunity, hopefully, for you to get a beneficial result in the lawsuit. That would be my summary of a lawsuit from beginning to end.